Good afternoon, everyone. Happy Monday. I call this meeting to order. Welcome to the meeting of this committee, number 76 of the House of Commons Standing Committee on Industry and Technology, pursuant to the order of reference of Monday, April 17, 2023. We're studying Bill C-434, an act to amend Investment Canada. Today's meeting is taking place in a hybrid format, pursuant to the House Order of Thursday, June 23rd, 2022. Apologies to our witnesses for the delay. We had votes in the chamber, so thank you for your patience and thanks for being with us on this beautiful Monday afternoon. So we have with us Laura Black, Senior Counsel, appearing as an individual. We have Kate McNeese, who's a partner in competition, antitrust, and foreign investment with McCarthy Tétrault. We have the Honorable Christian Paradis, lawyer and former minister, who is joining us by video conference. Hello, Mr. Paradis. And we have Bob Fay, Managing Director from Center for International Governance, Innovation, Digital Economy, who he's here in person. And then Gilbert's LLP, we have Tim Gilbert, Managing Partner. So thank you for being with us here in Ottawa. We have a good panel of witnesses. Without further ado, I will leave the floor to Laura Black for 5 minutes.
Good afternoon. I'm honored to be able to join today to speak about foreign investment review. Until October of last year, I was the Director of Policy and International Relations in the Office of Investment Security, that is CFIUS, at the U.S. Department of the Treasury. As you're probably aware, the Committee on Foreign Investment in the United States, better known as CFIUS, is the interagency committee that reviews foreign investment for national security risk. In my prior role, I led the process for drafting and finalizing regulations to implement CFIUS's new authority under a 2018 statute, and also led the international engagement function for CFIUS, where Canada was an excellent partner to the United States. I am currently practicing law with Aiken Gump, Strauss, Hauer, and Feld in Washington. Today, I'm speaking in my personal capacity. In establishing and implementing a foreign investment review mechanism, countries with open economies are attempting to meet dual objectives, protecting national security while maintaining an open investment environment. In recent years, governments worldwide have created or strengthened review mechanisms, for example, to require more mandatory filings to ensure they have the opportunity to review higher risk transactions, and in recognition of the fact that once material non-public technical information is shared, a subsequent divestiture cannot undo the damage to national security. These mechanisms vary by jurisdiction, and of course, each country must determine for itself where to draw various lines. I understand that committee members have inquired as a point of reference how CFIUS has approached certain issues, and I will offer background on 5 relevant issues. First, mandatory filings. In the US, filing is generally voluntary, with parties receiving the benefit of a safe harbor from future review once CFIUS is cleared a transaction. Recent amendments made pre-closing filings mandatory in 2 cases. Investments where a foreign government would acquire a substantial interest in certain businesses with critical technology, critical infrastructure, or sensitive personal data, called TID businesses, as well as certain investments by private companies into U.S. businesses with critical technology. Although other transactions involving technology are subject to CFIUS's voluntary jurisdiction, the mandatory filing requirement is only triggered with respect to a particular transaction where a government authorization would be required to export the U.S. business's technology to the foreign acquirer or certain of its shareholders. Thus, transactions that are likely to be riskier are the ones that must be filed mandatorily pre-closing. Other countries, such as the UK, Japan, and France, have taken a broader sectoral approach to mandatory filings. Second, regulatory scoping. For CFIUS, the broad contours of jurisdiction are included in the statute, with many key terms defined in regulations, which can be updated more easily. Particularly where filings are mandatory, best practice is to provide as much detail as possible. Third, interim measures. The 2018 legislation codified CFIUS's authority to impose interim measures while reviewing a transaction. Similar to the rationale for mandating filings, this can prevent harm to national security that cannot be reversed, such as preventing access to technology, though CFIUS has used it sparingly. CFIUS does frequently negotiate mitigation agreements to address identified risks. Fourth, confidentiality. CFIUS's statute provides an explicit exception to CFIUS's confidentiality requirements for sharing information with allied governments. Fifth, accepted foreign states. Here, I will note an area of difference. Like Canada, CFIUS generally applies to investments from all foreign countries, and there is not a prohibited list. However, the 2018 legislation provided discretion for CFIUS to give exceptions for certain investors. Currently, investors with a tight nexus to Five Eye countries, including Canada, are accepted from CFIUS's jurisdiction over non-controlling investments and all mandatory filing requirements. However, they are still subject to CFIUS's broad jurisdiction over transactions that could result in control. Finally, I will also note that Congress provided CFIUS a significant increase in resources concurrently with the expansion of its jurisdiction. Returning to the theme of protecting national security and open investment, this has allowed CFIUS to devote more resources to addressing risks while also more quickly processing benign transactions. I look forward to your questions. While I'm not an expert on the Canadian process, I am happy to share my experience on investment security issues.
Merci beaucoup, Madame.
Thank you very much, Ms. Black. Now we're going to Kate McNeese for 5 minutes.
Good afternoon, Mr. Chair and honorable members of the committee. My name is Kate McNeese, and I'm a partner in the Competition, Antitrust, and Foreign Investment Group at the law firm of McCarthy Tétrault. Thank you very much for inviting me to appear before you today. Before I begin my statements, I want to note that I'm appearing here in my personal capacity. The views expressed today are my own and not those of my law firm or any client of McCarthy Tétrault. However, my submissions today are informed by my experience assisting both foreign investors, including state-owned enterprises, and Canadian businesses navigate reviews under both the net benefit and national security provisions of the Investment Canada Act. I want to keep my remarks today brief, and I'm going to focus on just one aspect of Bill C-34 that I find welcome, the new provision empowering the minister to negotiate binding undertakings with the foreign investor to mitigate national security concerns. Under the current ICA, the governor and council can impose conditions on an investment in the final stage of the review, but in practice, this power has not been used since 2017. Empowering the minister to consider and accept binding undertakings during the primary national security review can improve the efficiency of the national security process by resolving matters prior to the final GIC review period. However, I believe the benefit of this provision will be limited if not paired with a greater level of transparency than currently exists. First, when a national security review is ordered, the investor is customarily provided with very little information about the nature of the national security concern. In my experience, the foreign investor may not be able to discern the precise nature of the national security concern, or even which business line or lines of the Canadian business to which it applies. This lack of disclosure means that the investor's ability to provide representations to the minister or to propose meaningful and practicable undertakings to address the concern will be limited, undermining the potential benefits of this new process. Second, the undertakings process will proceed more smoothly if there is sufficient context for the investor to evaluate the minister's requests for mitigation. If the minister cannot provide meaningful feedback to the investor on its proposed undertakings in the national security context, the undertakings negotiation process may move slowly or stall altogether. Finally, further public disclosure of the undertakings that are agreed with foreign investors is warranted for reasons of transparency and accountability. There are likely good policy reasons for not disclosing mitigation measures on a case-by-case basis. However, the minister could disclose mitigation measures on an anonymized or summary basis, as CFIUS does in the committee's annual report to Congress. This disclosure would improve the administration of the ICA by providing a remedial roadmap for investors, not to mention Canadian businesses, trying to assess the security risk proposed by a given investment. It would also demonstrate to potential investors that the undertakings process is not being used as a backdoor to obtain net benefit type of undertakings for investments that are not reviewable under Part 4 of the Act, and to highlight to the public the steps that the Canadian government is taking to protect national security while ensuring that Canada remains a welcome home for appropriate foreign investment. Of course, there will be information that the government cannot share with emerging parties or with the public due to security reasons. It may be difficult as a practical matter to find the appropriate balance, but by including in Bill C-34 measures to improve transparency, such as an obligation to provide reasons for ordering a national security review, a clear legal standard for national security undertakings, and a requirement to include information about mitigation measures in the annual report, Parliament can improve the efficiency of the ICA national security process and highlight its commitment to the transparency and rule of law in its administration. Thank you very much for the opportunity to present these remarks. I'd be happy to answer any questions.
Merci beaucoup, Madame.
Thank you very much, Ms. McNeese. Now we're going to Mr. Christian Paradis. Thank you, Chair. Hello, dear members of the committee. I would like to also underline that I'm appearing as an individual. My name is Christian Paradis, legal counsel and former member of Parliament for the beautiful riding of Mégantic-l'Érable. I'm former cabinet minister in the Harper government from 2008 until my retirement from politics in 2015. First of all, allow me to thank you for inviting me to the committee. 10 years ago, I was myself the Minister of Industry, and I'd like to take this opportunity to extend my warmest greetings to the colleagues with whom I had the privilege of sitting, and hello to the newer colleagues. The subject that is currently before this committee is of utmost importance. Our country has developed with a great deal of advantage compared to many others, thanks to its values based on those of a free and democratic society, anchored primarily in the rule of law. The strength and stability of our system is cited as an example in every corner of the globe. Our heritage as an open trading nation makes us a major economic powerhouse to this day. We are one of the richest places in the world in terms of resources, which makes us a popular location for foreign investment. With an ever-increasing volume of investment, and of course its share of challenges, the federal government passed about 40 years ago the Canada Investment Act. Our society has come a long way since then, and many things have changed. More specifically, it's fascinating to note the recent evolution of geopolitical and socioeconomic realities. Important trends were already emerging before the end of the last decade and at the beginning of this one, which resulted in a growing number of investment reviews on national security grounds. In 2012 also saw the publication of guidelines for the acquisition of Canadian companies by foreign state-owned enterprises. Fundamental questions of governance and transparency were increasingly being raised, and the government had to intervene for the benefit of Canadians. The upheavals in security over the last few years, if not months, certainly call for a review of the Act. I've taken note of Minister Champagne's comments to the effect that he wants additional tools in his toolbox, all with the main objective of protecting certain sectors of activity, which will be defined. So various levers are therefore proposed. Just to note a few: advance notice of investment, provisional conditions after consultation with the Minister of Public Safety, review extension, orders continuation, protection of information in the context of reviews and judicial review, communication of confidential information to other foreign states, and increased penalties. And as you all know, I also agree that the current context calls for a review of the Act, as fundamental issues relating to national security need to be properly addressed by the authorities. Given the importance of this issue, the work of this committee is extremely important. Dealing with issues that have international consequences sends out important signals that are far from going unnoticed, either positively or negatively. Markets are obviously the first to listen to such signals, and that is why this exercise must be carried out sparingly, identifying the right dose in terms of interventions, i.e. how to use the different levers, and especially how to frame these. I'm also of the opinion that the Act needs to be reviewed, and the levers identified seem appropriate at first glance. I do believe, however, that we need to be cautious with the implementation. It will be important to always aim to optimize transparency as much as that is possible, because you cannot reveal everything, of course, but also predictability and consistency of the procedure. Hence, the importance of identifying the right dose in terms of the application of the law, of the Act, via the various tools on offer. Rigid legislation risks cooling markets, as do directives that change too much over time. Thank you very much. Thank you very much, Mr. Paradis. Now we are going to Mr. Fay for 5 minutes.
Okay. Chair, honorable members of the committee, thank you very much for the opportunity to present here today. Please allow me to make 3 comments related to Bill C-34. First, intangible assets, and particularly data, have changed the nature of economic growth and created new value chains, and thus require a fresh lens and a renewed focus on the benefits and harms that may come from foreign direct investment. First mover advantages, economies of scale and scope, network effects, and asymmetric information derived from data create greater economic concentration that can leave Canada beholden to foreign firms and also reduce our economic resiliency. Further, foreign direct investment may be used to capture Canadian intellectual property and data that can reinforce such impacts. For example, data can not only allow investors to ring-fence a particular market, it could also allow investors to move into other sectors that may be sensitive and not anticipated with the initial investment. In other words, the capture of data can create issues across sectors and not just in a specific market. Thus, one needs to consider how data may be used across the list of sensitive technology areas and outside of them, and not just within those specific areas. And this can arise from any investment and not just those by state-owned enterprises. Data is extremely valuable. We have an idea of the aggregate value of data with experimental estimates from Statistics Canada, placing it around $200 billion Canadian, but we need more detailed and updated estimates. But because data is not explicitly valued on balance sheets, monetary thresholds for review miss the capture of data that may be the reason behind the investment. And data need not only be held in large firms, but also smaller ones, so where the investment takes place in the value chain is important. Second, data creates geopolitical issues that touch upon national security, and Canada needs to be active in setting global rules. Countries and firms are strategically setting rules around the uses of data, particularly personal data, that can give rise to national security concerns and have a direct impact on Canada. Canada needs to be actively engaged internationally in setting these rules, including standards, since Canada can be held accountable under such rules. For example, adequacy decisions by the European Union for its general data protection regulation. And just as Canada may be judged by its adequacy to rules set in other jurisdictions, Canada should also assess other countries on the prospective uses of our personal data and whether they meet Canadian values. So in this regard, it is important that Canada's own governance is up to date, for example, with respect to privacy legislation. And third, data requires a whole-of-government approach as well as new forms of governance. Although it is important to take a national security perspective to foreign investments, it also requires that other policy areas be taken into consideration, including privacy, data governance, competition and consumer protection, public safety, and so on, and a few examples. Investment that could lead to greater economic concentration may make our economy less innovative and resilient, and this is linked to competition policy. Personal data can be combined with other data to reveal patterns of behavior that can then be used to create social tensions and undermine our institutions and democracy, and this is clearly linked to public safety and national security. A recent example from the European Union and the United States that links privacy and national security is the so-called Schrems II decision from the Court of Justice of the European Union that invalidated the EU-US Privacy Shield, which relates to the cross-border transfers of personal data, on account of, quote, invasive US surveillance programs, arguing that it did not provide adequate recourse for individuals whose data may be used by US intelligence agencies. Our regulatory structures therefore need to adapt. As I noted in my submission to the consultation of the Competition Act, digital technologies are challenging all policy frameworks, and a broader regulatory and policy-making structures need to be considered. In this context, the interaction of investment reviews under the ICA and the Competition Act is very important. I would urge that decisions on investments wait until respective reviews are completed so that the expertise of each area can be drawn together for a broader assessment given the intricate linkages that may exist. Thank you.
Thank you very much, Mr. Fay. And now we'll move to Mr. Gilbert for 5 minutes.
Good afternoon. Thank you for the opportunity to address you today. I'm a litigator by training. I have a firm in Toronto called Gilbert's LLP. We work in innovation-driven clients that are dependent upon investment for IP particularly. And we also work with Indigenous communities, which increasingly are looking to expand their economic footprint. So my perspective is going to come from someone in the field, less at a kind of macro level, but more as a as someone, as a foot soldier out there trying to promote Canada as a great place to be and invest and for economies to grow. The Investment Canada Act, of course, I leverage off its original foundation. It seeks to strike a balance between national security and driving investment in economic activity. So I look at these proposed amendments, particularly we're going to focus on Section 11C, with a particular concern that I address in prepared remarks that I've handed up, and that deals with entities, the notion of what I see as a switch from the original Act, which defines a potential investment by a third-party entity, a foreign-controlled entity, into a Canadian entity, and that's what the Investment Canada Act, as it currently drafted, describes. The new Section 11C, as I read it, and I'm just a plain litigator out there dealing with these things and a business owner, but it describes an entity. It doesn't tie to a Canadian entity as defined under the Act. What that could lead to, as the definitions are currently in the Act that are disjunctive, it could lead to a situation where you have say, for example, a U.S. entity that's going to invest in another U.S. entity with a small operation here in Canada that wants to hire one employee and set up a place of business that might get material technical information as described, having to give notice to the Canadian government and wait for an investment to take place. I think it's a drafting error. I'm not sure it was the intent of the Act to do that. I could be misreading it. But certainly from a layperson's perspective, it would not, I don't think, achieve the objectives of this committee or Parliament to be trying to even have that long-arm reach to any jurisdiction outside of Canada. So from our perspective, in looking at it, we thought that it would be important to clarify the scope and the reach, that it looks like, and the Canadian Bar Association also pointed out, that it looks like it's overbroad. It should be tightened up, or at least, if not tightened up, delineate to Canadians who try to operate a business here, or to foreigners who are operating business abroad who want to hire a Canadian as to why we need to go through this process. And of course, Canada has a lot of skilled people. We're the highest skilled of all the OECD countries. We're trying to encourage people to hire folks here, and we're trying to encourage the placement of a business here. And the concern could be it's almost gone too far with this Act. The other concern, and this is, I mentioned at the outset that we do work with Indigenous communities. It's increased in the last few years. And I don't see any specific addressing of the concerns of Indigenous communities in the Investment Canada Act or the proposed amendments. And you could say, well, why is that? We're just concerned about foreign-controlled entities. Well, the perspective of Indigenous communities is that they have been historically affected by the Indian Act, residential schools, and long suffered under the reserve system, which took them and put them far away from the levers of economic activity. And they also have not been involved in nation-to-nation consultations towards economic sovereignty. So the Canadian government did specifically recognize the UN Declaration of Rights of Indigenous Peoples in June 2021 and is undergoing right now review of all legislation to see how that commitment needs to be applied. We're right now in committee. You're right now looking at an act that deals with investment, and the question is, and I don't know the answer, has there been specific outreach to Indigenous communities? They're increasingly, they can, of course, I can't speak directly, I'm not Indigenous, but I do advocate for interests like that, and a seat at the table, economic sovereignty is what they're seeking, and it would be interesting to see if the committee has received that input and considered even possible exemptions as they lean towards economic sovereignty. I don't know the specifics of how that would work, but I think that conversation should take place, and the committee should look at that carefully in consultation with leaders from First Nations and Indigenous organizations as they increasingly try to improve their economies. I also have read the brief of the Canadian Bar Association, generally support the recommendations, do think the definitions need to be tightened up, agree with the amicus suggestion in judicial reviews, and further would consider it a good idea to have safe harbors for startups. We have a group within our firm called Slingshot, which helps startup entities with a subscription model for legal services. We act for a lot of startups and small entities who are struggling to get money into their entities. And this country cannot be an island unto itself. We don't have the capital in this country that it can be deployed. And even the big pension funds, I can't tell you how many times I hear people say, oh, we'll get the pension funds to do it. The pension funds need to spread their money across the world, and they can't be an answer for everybody who has an idea. We're in a marketplace where it's very competitive, and we need to have access to capital. So that's the balance. I leave it to you, the good work that you have. I'm coming with a particular perspective and look forward to the discussion.
Thank you very much, Mr. Gilbert. So to start this discussion, we'll go to Mr. Williams for 6 minutes.
Mr. Jenner is going to go today.
Go, Mr. Jenner.
Thank you, Mr. Chair. I'd like to thank all the witnesses. Mr. Paradis, Christian, it's a pleasure to see you here today. Long time no see. And I'm happy that you accepted the invitation of the committee to talk about this important bill. Well, in 2012, I think you were the Minister of Industry and Innovation, if I'm not mistaken. You did do some changes to the Act to adapt it to the circumstances, as you mentioned, the Investment Act. And the changes you made at the time, compared to the changes that are before us today, do you see a big difference or something that would slow down the progress, if you will, because Mr. Gilbert was talking about important definitions. You also briefly referred to these. Do you have suggestions to us, or Mr. Gilbert, you can also answer the question, do you have recommendations about how we can redefine or define the different elements in the bill? Well, thank you, Bernard. I referred to 2012 because we had a situation whereby things were a bit more restricted in the sense that foreign state-owned companies were starting to acquire more and more Canadian companies. And so the question before us was about the different concerns from the public. And we also tried to keep the balance, and when I referred to a democratic society and our values based on that with market access, we wanted to keep that, of course. But on the other hand, you had state-owned companies coming from countries which did not exactly share the same values. So that was a bit of a risk that presented itself in those days. But when I look at the bill right now, it is interesting, of course, because there's this whole aspect of personal data and the technology aspect to it, and things change fast. We see that there are certain powers that can be better used earlier in the process. And when I referred to a balance, the Canadian Bar was also referring to the same thing, more or less. How should we define the different sectors of activity? Some were proposed, and these are obvious, but this also creates some concerns. If you go wider, then you can end up with a boomerang effect in the longer term in terms of the signals you're giving to the market, and scare off other investments which wouldn't really pose problems. You referred to the Canadian Bar and your own experience, Mr. Gilbert. So the definitions are key, as I see them. Do you think that they are too vague? Do you think that they should be changed and made more precise or specific? We had a witness before us, Mr. Basili from BlackBerry, who told us that Canada was lagging behind many other countries with the current legislation and even possibly with the bill that's before us. He didn't think that we were going far enough or fast enough. Do you think that this is true? Do you share this opinion?
Let me just deal with definitions first. I flagged the concern about the capturing of a U.S. entity or a foreign entity by a de minimis investment. I think that can be corrected by looking at Section 11C carefully and just putting the word Canadian back into Section 11C, which doesn't exist, before the word entity. So it would be a Canadian entity, and Canadian is defined in the Act, and then there's other provisions which people who do more competition law talk about the size, and then there's prescribed activities. But losing that notion of it being an investment in a Canadian entity, all or part Canadian entity, I think is something that is, that needs to be done at the legislation stage.
You referred to this within a human resources framework, but this also applies to foreign investment, potential investment, right? You gave the example from the U.S. In relation to human resources, but it also applies to potential investments.
Yes, absolutely. It's investments and location of businesses here, which, again, I think we want to encourage. So the other one that the Bar Association talks about is what does material, non-public technical information mean, and they suggest that should be teased out. The concern I have as a practical litigator who deals with trade secret litigation all the time is that it basically depends on the circumstance of each company. It's not something you can put a catch-all on. It's like a patent. A patent, you can get patents on all kinds of things, from zippers to whatever, and you try to define that, then you're taking that away from the unique circumstances. So effectively, it means, in my view, that practically everything is covered. If you're a shareholder and you're putting an investment in, you are going to be open under this legislation to having to submit that. And a conservative position as a lawyer would be to say, you better submit. I'm not going to hang my hat on the definition of you're not getting any technical information. How would you ever know? It's not even in the lawyer's control. It's back and forth between their client. So outside of their control, I would just say submit every time. You're making an investment, you better get into Canadian government, otherwise you could be offside.
And what about Mr. Basili's statement about the fact that we're behind other countries in this particular kind of law?
It's interesting. I don't have a comprehensive understanding of all other countries. What I can speak to is the atmosphere in Canada towards investment and the need for more investment. That is, in R&D particularly, it takes an enormous amount of money with little return, no knowledge of return. It isn't like saying I'm going to buy oil contracts and I've already got them lined up. I've got my customers lined up. That's more of a direct line for how you're going to make money. I've got the contracts lined up. In research and development, it is a risk. It is an entirely risky business. And at the same time, we tell the world we want to be a knowledge-based economy. We want to move from hewers of wood and extraction of minerals and metals, which is serve the country well, into the knowledge economy. But then you say, but I want to disassociate myself from the world capital markets, would allow that to happen. It is the tension in this act that my suggestion would be to maybe even look at either safe harbors or identify the countries of interest. If you really are concerned about particular countries, then the Minister, External Affairs, could say, we now are concerned about whatever that country might be. That might be another way to approach it. And I don't mean to throw a monkey wrench into everything, and I'm not a foreign policy expert at all. It's just I am dealing with companies trying to survive and thrive. And the way we thrive is to sell our technology and our ideas abroad. That's intellectual property. It doesn't mean you control it just here. It means if it's a good idea, it's a good idea throughout the world, and we have an expansive view to Canadian industry.
Thank you very much.
Merci beaucoup, Monsieur Van.
Thank you very much. Mr. Van Buynen, you have the floor.
Let the witnesses know this has been a very interesting discussion from the beginning, and I know that the real challenge is finding the balance between creating an environment that will attract investment, but at the same time addresses their risks. And generally speaking, the challenge with legislation is we tend to put up our guardrails through the rearview mirror. And what we need to do is give some consideration to what lies ahead of us. We need to be competitive on a global basis. And so my question first would go to Ms. Black, and that is, what are the other jurisdictions doing to address the national security concerns in foreign investment reviews? And does our approach align with those of our international peers, such as the Five Eyes partners? I know you touched on that early on in your presentation, but I'd like you to expand on that if you could, please.
Sure. In the last 3 years, over 30 countries. Is there a bad backfeed? Over the last 3 years, over 30 countries have taken action either to establish a review mechanism for the first time or to expand it. Canada, as you know, has one of the oldest investment review mechanisms. And CFIUS last year, as part of its accepted foreign state analysis, determined in the U.S. view that Canada has a strong system. I will say Canada's jurisdiction is expansive, where Canada perhaps had less authority than other jurisdiction is in the pre-closing mandatory filings.
Monsieur le Président, l'interprète signale que notre...
Mr. Chair, the interpreter is letting us know that the witness needs to reposition the boom mic on her headset for better audio.
So what I was saying is a number of jurisdictions have taken action to strengthen their investment review mechanisms, often to add more authority related to critical technology or data.
Monsieur le Président, la traduction ne...
Mr. Chair, we are not getting French interpretation because the witness needs to raise the boom mic.
Just raise the boom of your... We'll see, and I'll just wait to get the confirmation from the interpreters. If you could say a few words.
All right. Can you hear me now? Okay. Well, now that I've taken a bit of time, I'll try to be quick. To say Canada does, in the U.S.'s view, have a strong investment review mechanism.
Sorry, Madam Black, I think it's still not working properly.
Okay.
You need to raise it even more. Like, I know. Okay, yeah, I think that should be good.
So I'll wrap up quickly. I do think Canada has very strong, broad jurisdiction. Where a number of other jurisdictions have taken action is to have more mandatory pre-closing filings. The U.S. is on the narrower side of that in what is required, but a number of Five Eyes and G7 partners have taken those actions. I'll say that some jurisdictions have very narrowly scoped authority with respect to, for example, just infrastructure. So in many ways, Canada does have stronger jurisdiction than a number of other countries.
The last time the ICA was updated in 2009, this time I'll turn to either Mr. Fay or Mr. Gilbert. Can you talk about to the committee about the implications of the changing geopolitical landscape and the increased threat of foreign interference, and how it is now is the time to make these changes to the National Security Review Act?
Okay, thank you for the question. Exactly, things have changed tremendously. And I know I talked a lot about data, but data, the ability to harness big data has truly changed everything. And data, as I mentioned, is now a geopolitical tool. And it can be used, as I mentioned, you can feed it into various types of AI, if I can use that term. And it can be used to influence behavior. It can be used to capture markets. It can be used in many different ways, and we've seen examples of that. And so this is not something that was even thought about in almost any policy 10 years ago. And so most of our frameworks really need update, and this is one of them.
One of the things about data, extremely highly mobile. And the one example that I just reflect on was the Facebook movement of data from the EU to the United States. I think there was a fine of $1.2 billion. So my question is are our penalties significant enough? When you look at an organization the size of Meta or Facebook, $1.2 billion might simply be the cost of doing business. Should there be conditions, or are there any conditions attached to erasing that data, sending that data back, so that the penalty truly is a penalty and not simply a cost of acquisition? Go ahead.
Okay, maybe I'll take the first part.
Sure.
I mean, once the data has been integrated into the technology, it's done. So if there's benefits that come, the benefits are derived, or if there's harms, they're already there. So, and what you were, the fine you were referring to is the one I'd mentioned about related to the Privacy Shield and how the data were being used by U.S. intelligence services, or could be used, without recourse for the individual. So you do want recourse for the individual, but at the same time, you can give data back, but the data have already been harnessed by the technology and whoever holds that technology.
And are you aware of any organizations that consistently monitor the transfer of data to ensure that these types of events do not occur, or that what type of regulation and investigation authorities are there?
Well, generally what we do is we rely on other countries to follow their legislation. So, for example, in a trade agreement, you would say to the other country that you need to have adequate privacy protection over, let's say, personal data. And then you would rely on that country to enforce those rules. And that's why I mentioned, like from a Canadian context, it is important that we also, pass updated privacy legislation.
Okay. Do you have any time left?
If I might address your question about have things changed? Would that be acceptable?
Yes, you could go, Mr. Gilbert.
Thank you. I'd look at it in three different ways. Things have changed from just generally foreign interference in elections is obviously very topical. So seems to be much more activity, whether it be in the United States or here. And secondly, there's concerns about ownership and scarcity of essential resources. And thirdly, there's subject matter issues of whether it be data or those kind of things. I'd break down each into they likely have their own solution as it evolves and tweaking. So foreign interference can be dealt with, for example, a foreign agent's registration process. That exists in the United States. I myself was a foreign agent for then Her Majesty the Queen in America, in Washington, D.C., and it worked just fine. We did work for the Canadian, for Ontario, in solving a problem between United States and Canada. So that system was in place, has been in place many years, works fine. We just don't have it. Two, scarcity of resources, the Canadian government has addressed on particular issues of importance, as have provinces, on whether it be land, minerals, key concerns, where the government directs their attention to it and signals to the world, we want to restrict ownership or in a certain way and provide a key limit. And the third would be in subject matter, which something like data likely requires a deeper dive and more consideration than what's possible as a broad brush for every industry. So they're industry-specific approaches which likely should be considered as the economy has moved.
Thank you.
Merci beaucoup, Monsieur Lemay.
Thank you very much, Mr. Lemire. You have the floor. Thank you, Chair. My first question will be to Ms. Black. When there was a recent case in the U.S. in 2023, Caution High Tech, I believe, they produce batteries in China, and they signed a memorandum of understanding with a U.S. company to explore opportunities of a joint company in these new battery types, battery technologies and energy storage. And they are looking to co-develop a gigafactory of battery plant. Caution High Tech is not really investing in an American company, but investing in real estate rather, as per the agreement. And the CFIUS might not have all the competence necessary or the powers necessary to cover this cooperation between these two companies. And I'm wondering whether this might have an impact on the investment landscape.
CFIUS's jurisdiction is primarily over investments into U.S. businesses that are already functioning. CFIUS also has jurisdiction over certain real estate greenfield transactions around identified military facilities. This particular transaction was a greenfield transaction not near one of those identified facilities. Although I'll note that since this finding of not having jurisdiction, CFIUS has updated its list to cover it. So I think what you're pointing out here is that in the U.S., greenfield businesses are not generally covered for CFIUS review, whereas I believe they are in Canada. So I think what we're seeing in the U.S. are some proposals to expand CFIUS's jurisdiction, but we're not seeing anything moving in the short term. But as noted, CFIUS has regulatory authority to update certain of its definitions, and it has expanded the number of military sites around which real estate is covered.
Est-ce que
So there was a mining project as well. When you think about military projects, you quickly end up thinking about the reserves of strategic and critical minerals. Would CFIUS have anything to do in that type of a scenario?
So it would depend on how the transaction is structured. Again, I think Canada has broader jurisdiction with certain asset sales or greenfield transactions. If there was an investment into an operating company, which is a pretty low standard, if it has permits, if it's undertaken any development, then it could be covered. If it were a pure asset purchase, CFIUS likely would not have jurisdiction. Again, it's facts and circumstances, but that's the general answer.
mais ce type de partenariat
This type of partnership, once established, might it create national security concerns? Because if they gain access to strategic elements such as strategic critical minerals, because ownership of resources is a key issue in national security, or they might get sensitive information, maybe detained initially by their partners, but they might end up acquiring this type of information. Is this a concern that you have?
I think the approach, as I've said, the CFIUS takes is to review functioning businesses as opposed to startups where a foreign investor has come in. I take the point that it doesn't cover everything. It's one tool, and maybe I'll just leave it at that.
est-ce que
Do you think that these changes might have repercussions on foreign investment in the U.S.?
I'm sorry, do I think that what would have repercussions?
est-ce que cette modification
This type of change, would it have had an impact in terms of foreign investment in the U.S.?
If CFIUS were to revise,
cette révision-là mise en place, est-ce que ça peut avoir un impact sur la réputation des États-Unis?
So this kind of an approach, would it have an impact on the reputation of the U.S. and in the eyes of international investors?
I suppose expanding CFIUS's jurisdiction would cause more transactions to come under its review. I guess I'm not exactly sure what the question is. Is the question, if CFIUS doesn't cover these kind of greenfield transactions, what view does it have? I suppose on the Hill, there are a lot of discussions related to China specifically, restrictions, for example, there's a few acts in Congress, there's acts in the state legislature that would further restrict Chinese investments into real estate or critical minerals. So we may see some of them moving forward. You know, from what I've seen, the concern is more a domestic concern about control of those supply chains or critical minerals, rather than from what I've heard in talking to counterparts. I spent several years doing the international engagement function for CFIUS, and this wasn't something I had been hearing. I had been hearing mostly domestic concern about whether there needed to be more restrictions or review rather than concern from foreign partners.
Merci beaucoup.
Thank you very much. Thank you, Mr. Lemire. Mr. Massey for 6 minutes.
Thank you, Mr. Chair, and thank you for the witnesses for being here. Start with Ms. Black, just continuation a little bit here with regards to the United States process. How well has that been received by, like, say, for example, the Five Eyes with regards to security and modernization? And are the other countries also kind of in the same place for a review like this?
So I'll say, based on my interactions, the Five Eyes have generally seen risks similarly. Also, I think, you know, I worked quite a bit with European allies. I'd say if you look at 5 years ago, the US, Canada, and a handful of countries were the ones that had broader review mechanisms. I think over recent years, there's been a recognition that certain foreign investment does raise national security risks. We sometimes hear from foreign investors, and this was a point Ms. McNeese was making, saying that CFIUS actually does share more information. We do sometimes hear that CFIUS should share more information to allow parties to decide when to file, make better decisions on that. But generally speaking, I think countries have come more towards the Canada-US perspective on investment screening, rather than hearing a lot of concerns about pulling back in this area.
Yeah, I think things have really changed. An example, when this first came across an industry I raised a while ago, it was interesting. Canada used to have its own Petro-Canada owned as a state gasoline enterprise. In fact, it was divested by Canada at a time we were letting the Chinese communist government buy our oil and gas industry. So it was okay for the Chinese government to own our oil assets, but not for Canadians. In fact, we ended up losing out significantly when we sold the asset. If we don't do anything here in Parliament right now, it's not likely to come back in this Parliament. At best case scenario, we pass this bill now, it goes to the Senate, and we're looking at probably the fall for them to look at it and then either approve it or amend and send it back to us. If we don't do that, then we could be out of step for a couple of years. What do you think that would say for our country with regards to this issue? Is that if we stayed status quo for another year to 2 years?
As I mentioned before, Canada does have rather broad authority after the fact to review transactions, and Canada more blocking than mitigation for some reasons that have been discussed today. Canada, I think, was one of the earlier countries to actually take action. I do think, looking at the U.S. experience, we closed what we thought was a loophole, particularly with respect to high-risk technology, to be able to review those pre-closing. So I would say that I think it's important to have authority to review at least some of those transactions before the foreign persons of concern actually have the ability to access the technology or the data. But I will say, as I mentioned before, there's a pretty broad scope in terms of how much is being required pre-closing. I think you almost always see dual use, high tech. Some countries include agriculture. Japan has leather goods. So you see variations there, but I think some ability to review the transactions before closing is important.
Okay, and one last quick question to you, and it's good. I was just in Washington and was fortunate to have lunch with, at our table was Dick Durbin, who was doing the hearings with regards to artificial intelligence. Do you think that, given the emergence of that as a significant issue, that I guess that there's a general, assumption or at least appreciation that CFIUS is, and you did your updating as that's going on now, or would it be even a greater concern saying that if you didn't do that, and AI is now into the equation under the old rules? That's one of the things also I'm looking at as to reason, because if we had to go back, and deal with this, things could be totally different. We're just starting our AI stuff now. We're not even going to get to it if we're lucky to the fall, so we're even further behind.
So, as part of the amendments in 2018 that came into effect in 2020, CFIUS was able to close a jurisdictional gap. Previously, CFIUS had jurisdiction over transactions that could result in control of a U.S. business. What CFIUS was given authority to cover were minority, non-controlling investments in companies with critical technology, such as artificial intelligence, because what we were seeing was that some investors were coming in at lower levels where they didn't have control, but they did have access to material, non-public technical information. They had substantive decision-making over how that information was stored, cybersecurity protocols that could be violated. So I think for us, having additional jurisdiction to get to certain rights and access short of control was important for the U.S.
Great, thank you. And I think that's all my time, right, Mr. Chair?
You're correct, Mr. Massé. And I'll now turn to Mr. Fast.
Well, thank you, Mr. Chair, and thank you to all of our witnesses. I'll try to ask as many of you questions as I can. But I'm going to start off with my former colleague, Mr. Christian Paradis. Nice to see you again. Mr. Paradis, when you were in cabinet and you were the Minister of Industry, you had to address the issue of thresholds and when specific mandatory investment reviews had to take place. In your testimony today, you gave us very little, if any, indication as to whether you feel those thresholds should be reviewed. Not only given inflation, but given some of the evolving geopolitical risks that our country faces. Do you have any views on the nature and the adequacy of the thresholds that we presently have in place within the ICA?
Well, back in the days, we reviewed the threshold because there were two things. We were very concerned about what I described earlier about national security, dealing with state-owned enterprise, with opacity in terms of governance, and at the same time, we were of the opinion that it was a time also to review the threshold. It was time for going up back in the days because the threshold were not reviewed for a while, and the threshold with the markets, you didn't have the right calibration. So we didn't want to look like we were closing the markets. On the contrary, we wanted to send the signal that on both sides we were open for business. So we reviewed the threshold, but at the same time, not at any cost. So this is where it was important to review the rules like we did with the state-owned enterprise. I don't know if it answers your question, but that was the minding back in the days.
Okay. Now, just to understand, do you feel that the thresholds are still adequate today?
I checked the threshold. I see that there were some increasing with some breakdowns. So I would say that's hard to me. I'm not an expert in the area, but certainly I think that the threshold has to be, you need to make sure that the adequation is still there. And frankly, I cannot give you an expert opinion on that.
Hey, since you're an expert in governance, I believe, correct? Much of the power is being shifted to the minister from order in council or from governor in council. So the ICA is going to move to greater power vested in the minister to make certain decisions regarding investments and investment reviews. Do you have any views on whether that's appropriate or whether Cabinet should continue to play a significant role in undertaking these reviews?
Yes, this is where I think striking the balance is the essence. As I said there earlier, if the legal framework is too rigid, then you are stuck with some stuff that are difficult to change. On the other hand, if you go with only some directives that can be changed by ministers and their successors, that sends funny signals in the market. So you need to find the balance. And this is why also I checked with a lot of attention what the Canadian bar said. So when it's time to define what the sectors are, what do you want to regulate, why you want to do it, and then send the appropriate signal with an appropriate debate. So if you were to go with the regulations, then you can have a larger discussion.
Thank you.
If you concentrate everything in the hand of the minister, you will create likely some uncertainty.
Thank you. Mr. Fay, if I could get your views on that.
Well, I guess I would say that I'm not necessarily an expert in this particular area, but what I would say is that clearly one would want transparency over how decisions are being made. I think whether it be done, no matter what mechanism is used to approve a decision, one would want to know how that decision is going to be made, and then what factors were considered when that decision was taken. And if I may, to go back to your previous question, I mean, one of the points I raised in my testimony was data are not considered, the value of data are not considered in mergers. And I think that's a really important thing to keep in mind. They can be inferred through market caps and stuff like that, but it's not there.
Believe me, I took note of that comment, so thank you for pointing that out. Mr. Gilbert, very quickly to you. You mentioned safe harbors. I didn't quite understand actually specifically what you were referring to. Is it to data protection and privacy, or is it a broader application to investment reviews?
Sorry, I had in mind the Canadian Bar Association talked about de minimis investments up to $5 million or something like that. Certainly the first up to $1 million, it seems to be, that's hard money for a lot of smaller entities to get. It's not going to move the needle nationally, but it's critical, those type of investments for smaller entities.
So essentially having a reasonable threshold that will continue to act as a magnet for investment from abroad to make sure that our startups remain viable and are successful.
Absolutely.
Is that it?
Yes.
Those are my questions. Thank you.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Guerrier, for 5 minutes.
Great. Thank you, Chair, and thank you to all the witnesses for making time for the committee and their testimony. My questions are also for Ms. Black. I think it's just very interesting to compare the Canadian regime to the American one. In your opening testimony, you mentioned 5 points. I think a lot of them show that what Bill C-34 proposes actually brings the ICA in line with what the U.S. does. So, for example, Bill C-34, it authorizes the Minister of Industry, after consultation with the Minister of Public Safety, to impose interim conditions on investments in order to prevent the potential national security injury taking place during the review. Would you say that's in line with the interim measures that CFIUS has?
Yes, I would. That's in line.
Yep. There's also the improved information sharing amongst international counterparts. This act will it'll facilitate smoother international cooperation and information exchange so that Canada can consult with allies on potentially common national security threats resulting from transactions that are both in Canada and in other jurisdictions. Would you say that's in line with the confidentiality explicit exception that you had mentioned that CFIUS has?
Yes.
Yeah.
It's very similar, although CFIUS uses it quite sparingly and also ensures that if it shares information, it will be protected. But yes, it's very much in line with the CFIUS provision.
So mentioned that filing is voluntary in the U.S. unless the government authorization is required to export U.S. technology. And then you'd mentioned that other jurisdictions take a broader approach. Why do you think the U.S. Has a more narrow catch?
So I think this is a judgment call in the U.S. So originally we had a pilot program for mandatory filings for critical technology, and it was based on export control, but sectors. And CFIUS was seeing a significant number of lower risk transactions from countries that wouldn't cause concern. So there was a decision to focus it on when an authorization would be required to a specific country to align it more with risk. So CFIUS's view has been that it would rather see fewer mandatory transactions and have broader voluntary jurisdiction. So it will devote more resources to those higher risk transactions, let the majority of transactions flow without filing. But we also, at CFIUS, when I was there, set up an office whose function was to look at non-notified transactions to bring in transactions. So, perhaps here, CFIUS came down a bit more on the open investment side than some other jurisdictions. I'll also say, and going back to an earlier point, I think with the mandatory filing, we also tried to carefully scope that because 30 or 45 days can be quite difficult timing for private equity or VC funds. For normal M&A, that may just be part of a longer process with competition filings. But we heard a number of concerns from PE funds and VC funds about moving it at the speed of business as well.
You had also mentioned that everyone is subject to CFIUS. Would you be in favor of like a potential exception for certain nations where there is no concern? Could that speed certain transactions up, or do you agree that everyone should be subject to it?
So in the United States, we do have the accepted foreign state concept where certain investors with very tight ties to Five Eyes countries aren't subject to the non-controlling jurisdiction. All countries are still subject to the controlling jurisdiction. I think, to the extent you're having mandatory filings, to the extent you can focus on higher risk transactions, I think that's the right approach. I would be reticent to wholesale give up jurisdiction over control for all countries, because one of the things CFIUS is also looking at is third-party ties. So perhaps a company comes from a jurisdiction that's not of concern, but has extensive ties, for example, to a foreign government. That's something CFIUS could consider. So again, this is some balancing and line drawing.
Totally makes sense. You had mentioned that you're not, entirely familiar with the Bill C-34 or ICA, but in your time at CFIUS, looking at the development of foreign investment controls, investment security, and foreign investment review mechanisms, is there anything else that maybe the U.S. isn't doing that other nations are doing that Canada could learn from?
So I will say one thing CFIUS is not covering are research contracts with universities that can provide parties of concern access to technology that's being developed. That was the decision in the United States not to subject that to CFIUS, but some other countries like Denmark and I believe the UK are also considering that. So there are some jurisdictions that are more expansive. And then while I have the floor, just to go back to one of the other questions, I'll also note one of the questions I was asked was what might happen if the bill doesn't pass. I will note that in my experience, I do think Canada mitigates transactions less frequently than some other countries, particularly within the G7, and that perhaps could be because it's more difficult. So in the US, for example, CFIUS uses mitigation quite frequently to allow the economic benefit while conditioning, adding terms to the transaction. So I'll also note with respect to that other question that I think that's an important feature of the bill.
Great, thank you so much.
Merci beaucoup, Monsieur Lemire.
Thank you very much, Mr. Lemire. You have the floor. Thank you, Mr. Chair. My next question will be for Ms. McNeese. I especially appreciated your opening remarks. And I'd like to come back on one point on accountability on the part of the minister. What kind of advantages does that offer in terms of predictability and on the overall ecosystem within which companies will operate? What's the advantage of this increased transparency coming from the minister, do you think?
That's a great question. So I think one of the major advantages of moving this power to the minister is that there's greater flexibility within the timing of the transaction. The existing power to impose conditions on a transaction is in the final period of the review. It's the GIC review. It's only 20 days long, and that happens after up to 180 days or more of review that's already happened. So I know important work is being done behind the scenes to consider the transaction, assess the national security implications. That's all very important. But moving this sort of mitigation process into the main review, I think gives greater flexibility to, if a solution is identified and can be agreed more quickly to get that done efficiently and then allow, as Ms. Black said, the economic benefit to start for Canadians more quickly while preserving the national security. That being said, it's a real black box when you get to this process. It's by nature secretive because we're dealing with important and confidential security concerns. And there's very little disclosure, to the public or to the investment community as to what type of mitigation measures are imposed. So if you contrast this with the net benefit review process, which is very mature, it's been happening since the 80s, and there's sort of a set kind of landscape of undertakings that you can expect that you will have to give to the minister in order to get a net benefit review if you fall within one of the very small number of transactions that exceeds those thresholds. What I'd like to see is additional disclosure so that we can have sort of that toolbox identified to investors so they can understand when proposing an investment in Canada, when evaluating an investment in Canada, sort of what measures might be required from them to protect Canada's national security. So I think that sort of transparency and accountability is not only beneficial for Canada's status as a democratic institution and an open investment institution, but can help the process move much more efficiently.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Lemire. Mr. Massey.
Thank you, Mr. Chair. And to any of the panelists, do you have any financial or clients in this interest, either with a foreign government or a non-democratic government? Have you before represented any of those entities? I'll throw that open to the entire panel and see if anybody has any of those.
I've represented state-owned enterprises in respective reviews under the Investment Canada Act, yes.
Okay, and are you the only one, Ms. McNeese? I guess the others, I'll assume that's... So with that, Ms. McNeese, if we don't go ahead with some of these changes, what do you think would be the consequence to your clients in that with regards to uncertainty of the future? I'm just wondering whether, that also has and plays into the factor. Thank you.
Of course. So one advantage, I think, of these amendments would be the institution of these categories of transactions that will be covered, categories of businesses for which pre-closing notification will be required. So as we've, many of the panelists have discussed, both in this session and in previous sessions, the very broad jurisdiction of the ICA to require mandatory filings, but they're not necessarily pre-closing. So if you are an investor who perhaps is a state-owned enterprise and is aware of the current policy suggesting that investments by state-owned enterprises will receive additional scrutiny, or you're a private enterprise who's investing in a Canadian business that may have a potentially sensitive sector that it's involved in. The calculus for you is, okay, do I have to, I have to make a filing. It can be made either prior to closing of the transaction or following the transaction. And if I make a filing prior to the transaction, there might be, you sort of have to assess the probability that you'll be called in for a review, but you might see a significant delay because the process can be, 200 plus days long. So it's often this kind of balancing act of what's the timing for the transaction, what's the value we're hoping to create for the transaction. When we're representing Canadian businesses, it's, when can I achieve my return on investment in setting up this company by selling to an investor? And is there going to be significant delay or potentially a remedy? So we enter into this sort of difficult calculus as to, we all know a filing has to be made, and of course that obligation is going to be complied with, but when are we going to make it? I think by setting out a specific number of types of transactions, of types of businesses for which that filing must be made pre-closing, it will make that calculus much simpler for a lot of our clients. So I think that's one major benefit. I would observe, though, that this bill doesn't change the jurisdiction, the types of transactions that the minister can ultimately review. It changes the timing and the ease by which the minister can identify those transactions. I think that's a useful change, but I don't have the concern that we're suddenly going to be missing a whole category of transactions if this bill doesn't pass, because those will still be covered. It's just when they become, when they come to the attention of the minister and what can be done in that case.
Thank you. Thank you, Mr. Chair.
Merci beaucoup, Monsieur Williams.
Thank you very much, Mr. Williams.
Thank you very much, Mr. Chair. Thank you for our witnesses so far. I really want to drill down on CFIUS versus the Investment Review Division. Ms. Black, you've spent some time with that, so I'm just wondering if you could just comment based on two aspects. One would be CFIUS seems to be multi-agency, so it's in Canada, the Investment Review Division exists only in ISED, and those reviews are handled within ISED only and sometimes with the minister. CFIUS seems to be multi-agency, centered from the Treasurer Board, but and with the fence, but then exists across all agencies. Is that something you'd see as a recommendation for Canada? And can you just comment on the changes between the two?
Monsieur le Président, la traduction ne...
Mr. Chair, I did not get French interpretation while Mr. Williams was speaking, so I'm just hoping that it'll start again. Thank you, Mr. If you can start again, Mr. Williams, if you can repeat your question, please.
Ça fonctionne. Merci.
Okay.
It is working. Thank you.
Okay, thank you, Mr. Chair. So, Ms. Black, we're talking about CFIUS versus the Investment Review Division. Investment Review Division in Canada exists under ISED, and under ISED, those reviews are handled by one agency. In the U.S., that's handled by multiple agencies. CFIUS is in the Treasury Department, but then goes across all agencies, works at the Department of Defense and others. Can you please comment on that difference, and if you would recommend changes to the Investment Review Division in Canada that should be multi-agency?
Sure. So that's correct. In the United States, Treasury chairs CFIUS. There are 9 voting members, which are most of the cabinet agencies, including the Department of Defense. For each transaction, Treasury chooses a co-chair that helps lead the review, but it operates by consensus of all the member agencies and often brings in subject matter experts from across the government, which I think is a strength of the system. My understanding is that ISED does consult, although you may know better than I do, that ISED does consult interagency and bring in subject matter experts where needed. I don't have perfect visibility into that, but there are different approaches, kind of a hub and spoke. Some other jurisdictions perhaps are more similar to Canada. Some are more similar to the US. So I don't have a strong opinion on whether they need to be brought in every transaction, but I do think that kind of consultation ability is important.
Last point on this, when it comes to CFIUS versus the Investment Review Division, the Investment Review Division has public input where CFIUS seems to be less transparent. We did have a part of this bill that did talk about some parts of the ICA being able to be non-transparent, so secretive, with secret evidence and secret judges. Are there parts of this that you feel that CFIUS is warranted in having a little bit less transparency, or do you believe that we should find more transparency as we seem to do with the Investment Division, Review Division?
So I'll say, being on the outside now, I always say as much transparency as possible is preferable. In CFIUS's annual report, it does include information on the types of risks it reviews and the mitigation measures that have been taken. I know the relatively new assistant secretary has been doing more public engagement to try to educate businesses on what CFIUS sees as the risk. I'm always in favor of as much transparency as possible. For CFIUS, they do provide due process letters, for example, if they may be blocking a transaction, to provide information to that particular party about the risks to the extent it can be shared. But I do understand that some information, when it's classified, can't be shared broadly either with parties or the general public.
Thank you, Mr. Paradis. You were involved as a minister in the government in this part. Do you care to comment on the investment review division, seeing it be multi-agency? Any changes you would make to make it more similar to CFIUS?
No, frankly, it's as I said, the part that I worked on was more about reviewing the directives. But on the other side, I mean, I think we need once again to just hit the sweet spot about being very well aware about the things around the national security issues while we're open for business. But back in my days, I would say that on the net benefit side, the evaluation agency and so on, things were working properly. I don't think it changed since, but once again, it's always about hitting the sweet spot.
Thank you, Mr. Fay. You're talking about data a lot, very, very important. We've been dealing with C-27 as well, and some other. We talk about bills. It's good timing that they're all kind of being talked about at the same time. Intangible assets and IP, so let's include that with data. What recommendations can you make to C-34 that would protect, or at least review and protect, those assets in Canada?
Well, I guess what I would say is that, and it actually follows very nicely from your previous question, that they have to be considered. And so you do need that multi-agency structure to allow input so that perhaps the Competition Bureau wants to come in and say, guess what? The takeover of those assets may create concentration issues in particular sectors that can actually have public safety concerns. So you really do want to bring in the different perspectives. Our technology can be used for good purposes and bad purposes. And so I don't know much about CFIUS, but what I can say is what I've heard sounds very appropriate.
Thank you, Chair.
Thank you very much, Mr. Williams. Madame Lapointe.
Ms. Lapointe for 5 minutes.
Merci, Monsieur le.
Thank you, Mr. Chair.
In one of your responses, you talked about minerals and using that as an example. So I wanted to ask you, do you think this bill and the changes will help mitigate potentially harmful foreign investments in critical minerals?
Look, I'm not an expert in the oil and gas or minerals fields, so I can't really go too deep on that. I was just using that as an example of the government has the means available to control specific resources and specific industries right now.
Yeah, thank you. Especially important in this era of critical minerals and the demand for critical minerals. I have a question for Mr. Fay and Mr. Gilbert. What I'm realizing more and more now is that the reality is that it's very difficult to have and create legislation today that can keep up with the speed of advancements that we're seeing in technology. So my question is, how do we create legislation which accounts for this reality? How would you advise the government to be able to do that? Mr. Fay?
Okay, yeah, thank you for the question. Well, one mechanism that we've focused on is standard setting. And using standard setting can be quite nimble. It can It can be tailored, obviously, to technology, and it can embed the values over which we want the technology to be used. And then we can embed mechanisms inside regulations so that the regulations take into account the standards, and as standards evolve, that the regulations are modified. And in fact, we have a paper from CG coming out on this topic very, very soon that I'd be happy to share with the committee.
Well, from my own perspective, I don't know, is that on? Yeah. I would be concerned about a Canadian-specific approach in technology and IP. And the reason for that is to consider telecommunications. Remember Wi-Fi, how it used to be almost like impossible to do anything? And then a bunch of entities got together and really put a ton of money, billions and billions of dollars, into figuring out how to make Wi-Fi faster. And now we're into 5G now. That didn't come from a Canadian-specific standard. It's an international standard. That's how the world is working today. We need to be open to international standards and not set Canada-specific criteria. I'm quite different about that. IP, great ideas are great ideas around the world. And the more we're involved in that, the better. If you're concerned about foreign ownership, then address that specifically, but don't limit the world growth of technology and the spread of technology and ideas. So I have a very different perspective. I'm very IP focused on expansion, and we need to be part of that.
Mr. Chair, may I come in? Actually, I don't disagree with you. I'm not arguing for a Canadian standard per se. I'm saying that standards can be used, and it may be that we adopt international standards, or in fact, Canada can lead on standard setting in certain areas as well. Yeah.
I'd like to provide an opportunity for the other witnesses to comment on my question, if there is time, Monsieur le Président.
Yes, there is.
Ms. Black?
I don't have much to add from what the other panelists shared. I would say for CFIUS, for example, when it conducts its review, although it would look to see if companies follow prescribed standards, in part to determine if they're trustworthy, CFIUS can look at issues beyond standards, which may be set for different reasons. For example, privacy standards may be to protect individuals as opposed to protecting national security. So it may be one thing that CFIUS considers, but certainly CFIUS looks beyond that.
Thank you. Does anyone else want to comment?
So I wouldn't mind commenting if that's all right. So I think this is a really important question. In my experience, I think that the minister, when reviewing investments, will look at sort of intellectual property and tangible assets. I know that he'll consult with other areas of government, sort of to that question and get the perspective. And so I think that's an important part of the process that will lead to the protection of these types of assets. On your point about sort of regulating into the future rather than into the past, I think, or legislating into the future rather than into the past, I should say. I think this is one argument for the importance of deciding very carefully what aspects of this process are going to be set out in the legislation and which are going to be set out in the regulations that are associated with the legislation. The regulations being a lot easier to update. So something like the prescribed categories of business, for example, I think are well placed, as some of my colleagues have said in previous committee meetings, to be placed in the regulations and guidelines so that those can be nimble and flexible and updated to both address sort of new issues that are arising in the complex threat environment that Canada faces, and also to continue to inform potential investors and Canadian businesses sort of which areas are of great importance to the Canadian government.
Thank you.
Thank you very much, Madame Lapointe. So this concludes our last round of questions. And I want to thank the witnesses with us today for taking the time. This is our last meeting on C-34 before we head to clause by clause. So your words will be with us as we go to study the bill in depth and clause by clause. So thank you very much. Et sur ce, mesdames et messieurs.
And with that, ladies and gentlemen, the meeting is adjourned.
Merci à l'équipe.